My name is Dan Schulte. I'm the MDA's legal counsel, and today we're going to talk about covenant not to compete and termination of employment situations. The following scenario is a question that's becoming all too common these days. I worked for another dentist, and we had an agreement where I would buy into the practice with the understanding that one day I would buy him out. Our relationship became strained due mainly to a drop-off in business resulting from the economic conditions. He has terminated my employment. There was a non-compete clause in the contract. How enforceable is this type of clause in Michigan? Losing your job is bad enough. Losing what you thought was an opportunity to buy a practice and being stuck with looking for a new job that does not violate your covenant not to compete is even worse. Unfortunately, this is happening to young dentists more and more as older dentists are less able to afford retirement and/or stay busy enough to keep an associate busy. Let's take the issues raised in this scenario one at a time. First, did you have a binding obligation to buy the practice? The answer to this question depends on your employment agreement. Its language will control. What does it say? In order to create a binding obligation, it must both contain binding type language and include the material terms of the purchase transaction. Binding language would include a phrase like, employer grants employee the option to purchase, or employer agrees to sell to employee, or similar type language. Phrases like employer may sell to employee, or employee may be allowed the option to purchase, and similar expressions of intent only would not be sufficient to create a binding obligation. In addition to language sufficient to contain a binding commitment, the material terms of the transaction must be stated in the agreement. These terms must include the identity of what is being purchased and the amount. Is it stock in a PC, a membership interest in a professional limited liability company, or assets? The price must also be stated. Either a specific dollar amount must be provided, or the basis on which the price will be determined at some point in the future, such as fair market value, book value, or some other formula. Finally, the terms of payment must also be expressly stated. Will the purchase price be paid all at once? Will it be financed in whole or in part by the seller or a third-party lender? If the agreement provides that it will be financed by the employer, the specific terms of the financing must also be stated, including the interest rate, the repayment terms, security for repayment, and so forth. If either binding language or any of the material terms are missing, you will not have an obligation that is legally enforceable. Now let's turn to the covenant not to compete. You should first check the language of the contract to see if it applies when you are terminated without cause by the employer. This is something you should have checked before you signed the contract. In my opinion, it is unfair for an employer to insist that a covenant not to compete apply when the employer terminates without cause. Assuming your covenant does not have an exception for when the employer terminates without cause, it will be enforceable if the geographic scope and time period is reasonable in your situation. The geographic scope in most cases will be deemed to be reasonable if it is no larger than a radius necessary to encompass the area in which the patients of the practice live. As for the time period, 1 year is almost always deemed reasonable. 2 years is deemed reasonable most of the time, and in my opinion, no reasonable predictions can be made regarding terms lasting 3 years or longer. The bottom line is, your covenant not to compete is enforceable depending on its specific terms. Hopefully it does not apply in the case of an employer termination without cause. As always, having the assistance of an attorney experienced in dental office employment at the time you are entering into an employment agreement will ensure that you understand all of its future consequences. I hope this provides you with some helpful guidance.